I did a video a few months ago about how you might be eligible to adjust status in the United States if you are waived through the border. And it's called a Matter of Quilantan entry. And this video kind of revises the calculation about whether or not you should apply for that now that Donald Trump is the president-elect. Just a quick recap. You need to be inspected when you enter the United States to be eligible for adjustment of status through a marriage-based petition, inspected or paroled. So there was a recent program for spouses of US citizens where they can apply for parole in place. DACA applicants can also apply for parole. Parents of people in the military can apply for parole. And what this does is it fixes an illegal entry so that you're eligible for adjustment of status in the US if you have a qualifying family member who can petition for you. Matter of Quilantan says that if you're passing through the border and an immigration officer just waves you through or sees you and doesn't ask you for your documents and assumes you're a US citizen or permanent resident and just allows you through, that counts as an inspection. How does this actually happen in real life? Let's say you're a child and you're sitting in the back of a minivan and the driver of the minivan is a US citizen and the driver just begins driving through the Mexican-US border. Customs officer only speaks to the driver and asks the driver, "Are you a US citizen?" And the driver says yes and shows a US passport, and the officer just waves the whole van through. In that situation, you have been inspected and you might be eligible for adjustment of status in the United States. What we would need to do is prepare a detailed affidavit, which is a statement from you explaining all of the details and circumstances about when you entered, how you entered. We would provide as much corroborating evidence as possible. And then there's a good chance you'll be interviewed to ask you about the facts and circumstances of your entry. If the immigration officer actually believes that you were waived through, which happens all the time, then you will be eligible to continue with the adjustment of status process, which is typically through a spouse or a child petitioning for a parent, something like that. But now there's an added wrinkle. Last time Trump was president, he made it such that anyone whose adjustment of status application got denied was automatically placed into removal proceedings. So now there is the added risk, assuming that the policies from his last presidency carry over into the new presidency, that if you apply pursuant to Matter of Quilantan and you write this detailed statement explaining how you were waived through the border, if the immigration officer doesn't believe you, you can very well be placed into deportation proceedings, whereas before this policy, your application would just get denied. The risks are much greater now. So let's say, for example, there's a husband and wife, and the wife is a immigrant spouse and the husband is a US citizen, right? And so now the wife is considering applying for adjustment of status because she was in fact waived through the border many years ago. And she's going through the calculation about whether or not it's worth it. And then we do a consultation and I decide, based on the facts, I think there is a chance your application get denied. And for just this hypothetical, let's say that chance is 20%. So now there's a 20% chance that your green card application will get denied and you'll get placed into deportation proceedings. At that point, we would have to see whether you're eligible for any defenses from deportation. You might be eligible for something called cancellation of removal. For example, if you have a child who has any developmental disabilities, or if we can prove that you have a child, spouse, or parent who will suffer extreme and unusual hardship if you're deported from the United States, and this child, spouse, or parent is a permanent resident or US citizen, you might have a strong case in the event that you're placed into removal proceedings. So the calculation has changed, and we might do the consultation and I might decide there's a really good chance the immigration officer is going to have a problem with your story because there's no corroborating evidence, the details are weak, you don't remember enough of it, the risks are high. In that case, let's just wait until the president changes. And then your response might be, yeah, but what if I'm targeted by immigration during the next 4 years? Well, in that case, if you're actually placed into deportation proceedings and we have to defend you in immigration court, you might still qualify for applying for adjustment of status pursuant to Matter of Quilantan, or this example where the wife qualified for cancellation of removal. So that would all be a part of the calculation. If you're considering applying for adjustment of status through marriage, that's something that I focus on. It's what a lot of my cases are. We can do a detailed consultation going through all the pros and cons and just figuring out what the risks might be associated with that and what plan B or plan C might be in the event that the worst case scenarios pan out. If you're interested in scheduling a consultation, you can find my info in the video detail below, or you can go to my website and check it out. You can schedule a consultation directly through my website. If you're interested in learning more about family-based immigration, such as adjustment of status through a marriage or naturalization process, be sure to subscribe to my channel. I go through these topics on a regular basis, post at least one video a week, and I'll see you guys next week for another one.